This is D155222043. Looks like we have counsel and the defendant present. Why don't you just state your appearance?
Good morning, Your Honor. Trevor Creel, wire number 11943, here on behalf of the plaintiff, Tara Kellogg.
Good morning, Your Honor. Alex Ghibaudo, the proper person.
Okay, Mr. Ghibaudo, you, when you came in and checked in with the marshal, you said you had a financial disclosure you wanted to share.
I do, Your
Do you
Honor.
have a copy for Mr. Creel?
I did. I provided him a copy. There's one copy of the tax forms that were provided to me by my accountant.
Do you want to have these filed, or do you want to just exchange them?
I prefer to exchange them, and the reason is this. I've mentioned this in the last hearing, but the plaintiff has friends who she provides documents that are filed in this case, and they subsequently post them online on social media. So anything that happens here is filed, it ends up online, and embarrass me. But these are personal financial information.
Okay, well we can, the requirement was that you make a disclosure of your finances. So make sure that, so we can, you know, if it had to happen this morning, it happened this morning. I can issue orders in this case that can at least put parties on notice that the documents that are filed in this case related to finances are only used for the purpose of this case. So,
the problem with that, Your Honor, is that anything that's filed, whether it's under seal or not, it's accessible at the clerk's office. What I would suggest to make it part of the court's confidential file.
Well, it's a, we'll make it an exhibit, which is a clean way of doing it. Mr. Creel, you can use it any way you want.
Sure, and just to be clear for the record, I received a handwritten copy of this FDF 5 minutes ago.
Yeah, well, I haven't seen it. He came in, and as he checked in, he said, I have a document, and I said, just hold on to it. We'll talk about it when we get there. Look, the approach that the court took in setting the matter in October was, let's get on a payment record. We don't want to do this every month, but there was an offer that there would be a payment made. There was confirmation that $3,500 was paid on October 12th. We set the matter over to confirm another payment. I don't want to do this every month, but I want to make sure that, the best defense to the contempt proceedings are payment. We finally got an order approved. I looked at it last week and I went through it, and I think it got filed and there's a notice of entry. So we've sort of taken all of the issues that were addressed in early October and issued judgments that would close that piece of the case. Were you able to make your payment on time?
No, Your Honor. And
what did you pay?
I'm prepared to pay today. Here's what I've been doing. If you will take the FDF so you can review it.
Well, Randy, I'll take it. I'll give it to the clerk. We'll have it marked as and admitted as Exhibit A. Marking it and having it admitted means it stays in the vault. Hold on.
The FDF is
all right. Well, let's go back a step and try to have some formality to what we're dealing with here today. The court continued to order show cause and set the matter over so that we would be able to confirm that there was an additional payment to your client, Mr. Creel. It sounds like Mr. Ghibaudo was prepared to make a payment but hasn't made a payment prior to the hearing, right?
He has not made
your client is expecting $3,500, no less, today.
Yeah.
All right. So that's fine. Let's hear what Mr. Ghibaudo has to say. I've been presented with a document which looks like a profit and loss statement with a financial disclosure form. The financial disclosure form has a...
He doesn't attach any of his schedules. He doesn't even complete a detailed FDF.
You don't need to criticize it yet. It's signed by you today. This is offered to the court as an accurate record?
Yes, sir.
Okay. You're a debtor as it relates to financial obligations. You are subject to a notice and to answer questions as a debtor in the form of a debtor exam, which is one likely step for them to follow up. There isn't any let's focus on what we're here for. The court received confirmation that you had made a $3,500 payment on October 12th. We set this over for today so that you could get on schedule for another payment about 30 days from that hearing. You said that you're prepared to make some sort of payment, but I want you to tell me what you're prepared to pay and then try to put some of this financial disclosure in context, okay?
Very well. So what I did since the last hearing is I made every attempt possible to come up with the money to pay that, but just can't do it with the expenses that I have now. So what I've done is I actually had to cut loose my associate attorney, which means I have to bear the entire burden of the entire calendar as well as generating business so that I can pay her. So that she gets paid, I have to let loose my associate and I have to handle 80 or 90 plus cases and run the business. The other thing that I needed to do, because I'm behind on everything, I just started this in June. This isn't like it's a thriving business that's been around forever. And I'm starting already with a red flag, with a history of suspension. It doesn't make it easy for me. That being said, I've done something with it. Since June of 2016, it's incrementally come up to the point where I could start making regular payments, I think, if it keeps going the way that it has. And I provided a P&L with the third quarter gross receipts so that you can see that it's been kind of ticking up. But I just can't, I couldn't, and I right now cannot make the payments that they want. But what I've done in order to do that is I've gotten into ever more debt. So I got confirmation from one of the creditors that I have, Yellowstone Capital. And the broker said that he's 90% sure he can fund me tomorrow with at least $7,000, if not more, based on the November statements to date.
Well, what are you prepared to pay today?
I can't pay anything today, but if he funds me, the funding will occur tomorrow. It should be wired tomorrow immediately, whatever it is that this
Let me,
Problem is that anything that I pay her creates, I can't pay her anymore. That's the problem. I just can't pay her what she wants.
well, okay, but payment of nothing is not that, we had a long discussion about this last time. That is not the approach that's gonna get you out of this issue with the court.
The other problem, Your Honor, is frankly, it's incredibly aggravating. It saps my motivations. And every effort that I make, I'm undermined by her and her counsel. She's busy online trashing me, undermining every effort that I make to make money, and her attorney is sending grievances to the state bar every chance they get. I don't understand how it makes sense for an attorney who's trying to get child support for their client to tell the state bar that I'm in arrears on child support, which possibly endanger my ability to earn. It makes no sense, but that's what they did, and now I'm dealing with the state bar on that issue.
Okay, but you're making.
Then we talk about the order, discuss the possibility of just naming it family support, because that's what it was in the beginning. It was family support until they decided it was child support. They created that decree out of thin air. There was no child support order, it was family support. And then they created a number that I earned. I wasn't earning anything at the time. I wasn't making any money. They threw in a number, 6,000 and change. And then they decided this is the amount for child support. How you discern the two, how they got that out of thin air, I don't know. That's how they do business. It's just this how they operate. In February, a decree was entered. All of a sudden, I got child support arrears. Despite the fact that I paid more than $30,000 to this woman since forever, and the money I don't have, money that I could have used to build this business, she could get paid more. So my daughter actually has money. But instead, they're hounding me for a year and a half now. I've been hounded. This morning, I'm dealing with this case. I could have been billing clients. I could have been handling cases. But I'm dealing with this case. For a year and a half, I've been dealing with these people. How am I supposed to grow this business and make it advance when I'm dealing with this? It's the most I'm prepared to roll it up. Call it quits. Because who needs this aggravation?
Well, is it really impossible for you to just make a monthly payment every month?
It's not it's not just the monthly payment, it's the harassment, it's the bar grievances, it's the constant court appearances, it's the attorney's fees, the endless requests for attorney's fees, the mountains of documentation. Why are they filing supplement after supplement after supplement? The briefing's done. I don't remember this court giving them leave to supplement anything. But there they are, submitting it, and I'm gonna get a memo of fees and costs like the last one for $54,000, $2,000 of which I'm ordered to pay, based on that I have to review, I have to go over, I have to deal with. It's constant, it never ends. It never ends with them. And I've been dealing with this for a year and a half. This case is not, we settled this case. This case was fine until they came on board, all of a sudden, we're here.
But the settlement of the case includes those agreements related to
Get a job, all
family
of that.
and stuff.
Whisper under your breath.
All right, look, the court doesn't intend, if the payments had been made, then the court wouldn't be bringing you back here every month, okay?
It's not what the court's doing that I appreciate the court's efforts of getting control of the situation. It's a lot better than it was. I have run into a situation where it's either pay a bill that's going to further and advance the firm or pay her. And the reasoning that I have is, I can pay her now and everything goes under and I can't pay her again. I'm back in court because these people won't stop. Apparently they're doing a pro bono for her, and then it's a mess. So all I can do is explain to the court where I'm at, what I'm trying to do, and how I'm trying to make an effort to pay. It's just a matter, I need time, and I've been trying to tell them this forever. I need time to build a business, a situation where I can actually afford $2,500 a month at a minimum.
Well, you haven't paid anything since the $3,500 in October, so it's not like I can even weigh whether or not it's a reasonable approach. I mean, basically what you're doing is you're saying, look, I'm gonna try to borrow some money, I might be able to borrow $7,000 by Wednesday.
No, tomorrow they'll fund me. This is how they do business. I've been dealing with them for 2 weeks. It's a race against time.
Okay,
And the week before that, I ended up in the hospital.
Okay, but look, what can you perform? I can set this over till Wednesday, and confirm a payment? Is that what you're asking me to do?
Friday, I got many payments that I can collect by Friday. And I have no problem paying them by then. Although it's a payroll again, it's gonna be strapped, but I'll make it happen.
Well, I can do that.
I'm working on this for 3 weeks. Something's gonna happen.
You have to, well, look, you've been in the situation where you're the lawyer and you're trying to counsel your client on how to deal with the emotions of litigation, right? So you're trying to do both, which is not easy.
It's not.
But you also know in your head, I know you know in your head, that the best approach to put this behind you is to get into a situation in which you're methodically paying at least the base that you owe. And then the court is not interested in the type of remedies that you think that they're interested in, okay? The problem that you have is that each time we come in here and each time that we have a record that we're, of non-payment or additional time, the court is, it makes it harder and harder to be flexible concerning your obligations, okay?
I understand that.
I have a hearing on Friday morning. I did this with you guys in October. I want to make sure that she gets paid, and that's the enforcement tool of indirect civil contempt. So if she gets paid and you can get it done, then it mitigates the, it basically keeps me from taking the next step, okay? Mr. Creel, what are you doing on Friday morning?
On Friday morning, the problem is when we keep coming back here, that costs my client thousands of dollars.
You don't have to be here. If you receive the money, you don't have to be here. We simply either decide to have another date or whether we require you to just set it for hearing. Nobody required you to do anything except show up and tell me whether you paid or not for this hearing. And the court already,
Prepared order, but no.
well, that was to facilitate. That order was important. That order tied up a lot of loose ends between the time of the stipulated divorce decree and all the other nonsense that I didn't know that much about because I just got this case, okay? And you did a good job, and I approved it.
So with regards to the court's question on Friday morning, I am available. The reality is that the court issued an order on the 16th that he make payment of $3,500
Right. So the issue
by
is
today's date, and he
what's-
hasn't done that.
Well,
It's an
and so
additional
what's,
contempt.
so what's the court's gonna? Yeah, but contempt is my.
I understand.
I want him. He's giving you some financial information. You can chew on it and take a look at it. I didn't really look at it, but it's been. The court is going to insist on performance on the promise to pay. I don't know what to make of this promise that says that he's either going to collect retainers or he's going to borrow money. It's essential that you get this thing, you stay ahead of it. You're not ahead of it, okay?
No, I'm not.
And
Was not contemplating having a business at the time that this agreement was entered. And the way that it's structured invites ad nauseum litigation, and it's set up without any consideration of whether it even makes sense.
there is
for
a
business.
minimum payment that you must make. The amount that you are paying is less than what's in the stipulated judgment, right? Based on
No.
income. The way that you set up the agreement does invite scrutiny over your business, okay? And frankly, we're not here to discuss that. It's a difficult issue for the court because the agreement is a contract, it's a stipulated judgment, I can't ignore it, and I'm gonna have to deal with it when it comes up as it relates to that. But
It has to be modified, Your Honor. There's
don't bother with those kind of arguments. All it does is cloud the issue. The issue is your performance on the payment. The purpose of the hearing today was to confirm that you've made your second payment since I issued the show cause. You appeared today and provided financial information. You have not made the second payment. The court continues the order show cause to 9 o'clock on Friday morning. I would not wait until that payment is made. If you can make it before then, I would get receipt and get it paid, because the first thing that comes out of my mouth is going to be, did they pay you the money? Okay?
It'll get done.
All right. So the matter's continued over to Friday. That includes all issues.
So the issue of attorney's fees, we have filed a memo of fees and costs. The court indicated it was going to issue an order relating to that. Are you deferring that as well?
What did I just say?
Okay.
I said everything that's on for today.
Because the reality is, Your Honor, how many times are we going to be forced to come back here?
I don't know. If there had been payment before today, I might have said we don't need to do this every month, but I may have to look at that again.
But this is what you're going to continue to hear. I'll promise to pay. I'll promise to do what you ordered, Judge. I'll promise to file a detailed FDF, which he hasn't
Because
done.
I have
I'll
no
promise to
issue with
supply a
paying,
tax return,
I've done
which he
nothing
hasn't
in this
done.
case. I've only paid $30,000, paid $3,500 at great expense myself last month when the court ordered it. Made every effort to pay now. This is what I had to deal with.
Take a breath. Take a breath. Okay?
And this is what I hear outside, Your Honor. F this, F that, F this. This is the way he communicates with me.
Well, the impulsive nature of that is not productive. It's not professional, and the enmity here isn't necessary. This is a financial dispute. Okay, you have an obligation to pay. Okay, make your payments. If there's a dispute down the road that I got to deal with because they think that the amount that's ordered is not consistent with the agreement that was entered, or and we have to open up that dispute as it relates to whether they want to increase the payments or whether you want to modify the agreement, I'll deal with it then. But that's not what we're here for. The last hearing in October and the hearing today has been to rein in all of the financial disputes that have happened and to get collection and enforcement on the order ongoing. So the dialogue, I mean, it's okay for you to kind of share what your point of view is as far as where we are. But we're not here expecting rulings on those kind of issues, okay?
He's still not paying the child's medical insurance either, pursuant to the terms of the decree.
Yeah, and
I mean, can we just make it a record? I would love to come in on Friday, put him on the stand, you issue contempt orders, and then actually force him to comply with your orders, Judge. He doesn't care what you say. He doesn't care what his agreement is. He doesn't care what we say. He doesn't care what the state bar says.
I would say that that's unlikely because I'm piggybacking you on the front of a trial. If we do that, then I'll be asking questions like, does he want to have an opportunity to get counsel? If the court is going to consider whether or not we use coercive powers of, but we know that it is when I issue a contempt sanction, that's going to have significant consequences. And I'm going to give Mr. Ghibaudo every opportunity to avoid that. But, you know, this doesn't help. Okay. All right.
Is he actually going to supply his Schedule C, his tax return? Should we be expecting all of that?
The kind of questions that I would ask him is, remember he said he was getting ready to try to file his tax returns.
Right.
Have you filed them? If you filed them, you should have had them already. I don't want to get into a dialogue about what the status is of those returns. You know that you have to provide your return. I assume that because you didn't, you haven't filed one, right?
I haven't filed it yet, Your Honor. The other issue again is that everything I provide to them is above line. If we get a promise that that's not gonna happen, or some more from the court, no problem disclosure. The other problem is the last time I provided bank statements to them, they submitted a ring of execution on my business accounts after Judge Brown told her that's a separate property that shouldn't be.
No, she didn't, but.
Oh, no, she actually did. If you want to lie, I can pull up the record where she stated that.
All right. It matters that concerning the status of the compliance with the order and the payment is continued to Friday at 9 o'clock.